Hello, everyone. Thank you for listening to our CCPA overview. We are joined by Ed Barton, who is our CEO and also an attorney admitted in the state of California. And we also have Alex Papadopulos, our CTO, who is responsible for our cybersecurity. So today we're going to go through what CCPA is, the penalties for non-compliance, your role in following these regulations, and our role and steps we're taking with your website. Ed, do you want to start us off with a few definitions?
Certainly. Thank you for listening, everybody. And I just want to put the classic disclaimer. This does not constitute legal advice, nor does it create an attorney-client relationship. I want to walk through some definitions for you that you've probably heard around privacy policies and CCPA. CCPA is the California Consumer Privacy Act. It was put in place about a year ago, effective January 1st of this year, and it regulates how information from a consumer may be utilized in the state of California. It was based on a regulation known as GDPR, which is the General Data Protection Regulation out of the European Union. That's been in place for several years, and many multinational companies have been under the requirements of GDPR. That was the impetus for a lot of the banners you see pop up at the bottom of websites that say, we use cookies if you want to use cookies except here. And then there's PII, and PII is personally identifiable information. And this is the data that is most critically covered under both CCPA and GDPR. So I want to get into a little bit around the definition of PII because this is important. This is the data that is going to be most heavily scrutinized by the state of California and by private parties when meeting requirements of either CCPA or GDPR. It's pretty much any information that can allow you to identify a specific person based upon even triangulation of various data points. And so the typical ones are things like name, address, phone number, email address, social security number, driver's license number, etc. This is the typical things that you think about PII. However, there's a lot of other information that falls into PII, particularly when coupled with any of those items listed at the top of the slide. So biometric information such as DNA or fingerprint information, audio, electronic, visual, thermal, olfactory or smell or similar information. Additionally, when you're looking at your digital marketing and digital presence, things like browsing history, search history, geolocation data, and information regarding a consumer's interaction with an internet website can also be considered PII when bundled with name, address, phone number, email, or other information that can allow you to identify a specific person. Additionally, education, professional, or employment information are defined as information or any information defined as not publicly available. So if they've got it publicly available, it isn't necessarily PII. So what does the CCPA say? CCPA gives consumers a right to know what information is collected about them and whether you're using that information and how you're using it. And so you've got to provide the consumer with information around whether and to whom their personal information is being sold or disclosed and allow them to opt out of the sale or disclosure. They should have access to their personal information that's been collected and have an opportunity to have the business delete their personal information at their request. They are not to be discriminated against for exercising their rights under the Act, which means if a consumer is going to provide you with personal information or not provide you with personal information, they need to be treated similarly if there's a disclosure. You can't have a quid pro quo for giving personal information out. And the CCPA prohibits selling personal information of a consumer under 17 without consent. Children aged 13 to 16 can directly provide consent. Selling personal information about a child under 13 requires parental consent. So again, there's a number of areas on the CCPA. The general overriding issue is that consumers are deemed to own their personal data and have the right to know how you're using it and can direct you on how you can or cannot use it. There's penalties for noncompliance. I want to start with the comment up in the upper right, which is the Act generally grants companies a 30-day period to cure any violations. And so when you're notified of a violation, you have 30 days to be able to get your house in order, so to speak, and meet the requirements of CCPA. There's two ways that you can be notified. One is through a state action through the Attorney General's office, and the other is through a private action from an individual or their attorney. If the violations aren't fixed within that 30-day period, or if they're unfixable, consumers can seek the greater of actual damages or statutory damages ranging from $100 to $750 per consumer incident. So if you have thousands of consumer data points and you're in violation, particularly if it's an AG violation and the Attorney General's office is coming down, you could be liable for hundreds of thousands, if not millions of dollars worth of damage. Courts can also impose injunctive relief or declaratory relief, which essentially is to order you to do something or to stop doing something. There's, in addition to that $100 to $750 per consumer incident, you've got up to $2,500 for unintentional violations of the Act and $7,500 for intentional violations of the Act, and those are in Attorney General actions. And then, as I mentioned, the $100 to $750 per incident or actual damages, if higher, are at the individual level. So this is a situation where noncompliance could really make or could really break your business. So who must comply? The CCPA applies to for-profit businesses that collect and control California residents' personal information that do business in the state of California and meet one of these three requirements. The first requirement is you have annual gross revenues in excess of $25 million. If you're in excess of $25 million and you do business in the state of California or with California residents, you're covered. If you receive or disclose personal information of 50,000 or more California residents, households, or devices on an annual basis, you're covered. Or if you derive 50% or more of your annual revenue from selling California residents' personal information, you're covered under CCPA and must comply.
So we'll talk a little bit about what you as a dealer need to do to comply with CCPA. Number one, most importantly, you need to have privacy policies and notices that are prominent on the website or accessible on the website that describe what data is being collected and what is happening with that data. So if you are selling data, your notices need to describe what data is being sold and who it is being sold to. You also need to be able to respond to and allow for consumer requests to delete their data. So you have to have mechanisms in place to be able to take those requests and act on those requests. You also have to allow your consumers to be able to opt out of data being sold. So you can still collect data in these cases, but you have to be able to mark those records as not sellable to third parties. If you do sell data, and if you do sell consumer records, you have to provide the notice, as I mentioned in the privacy policy, but you also have to tell them what is being sold if they request that and who it has been sold to. A consumer also has the right to request information that you have collected on them. So along the same lines of being allowed to delete their data, you also have to provide mechanisms for them to request what information you have stored on them. And then very important, as Ed mentioned about the different age groups, you can never sell data for children under 13 years old without parental consent, and you cannot sell data for children aged 13 to 16 without their direct consent. What do your vendors need to do? So your vendors, as primarily the conduits of data into your systems, need to reasonably protect the data. That is not yet defined in CCPA, but as a vendor, we are taking practices that we're looking at guidance from other pieces of legislation like GDPR and typical security and compliance processes to make sure that the data is protected within our systems. You need to make sure that all vendors are doing the same. Your vendors also need to allow consumers and clients to request the deletion of personal data. In most cases, under most circumstances, those requests will go through the dealer to your vendor, and the vendor will be requested by you to delete the data if you get that request from your customers. The privacy notice has to be posted on those vendor systems, typically as a website provider. That will be the most prominent area that a consumer will be able to go to look for those privacy notices. And then your vendor also needs to facilitate the processes for data collection. In most cases, your vendors will be processors of the data and not the master storage of the data. So you need to make sure that they are following best practices in terms of collecting that data and transferring the data to other systems. So what actions is fusionZONE taking? Number one, we are alerting all of our California dealers to the requirements. We are advising our dealers of the specifics within CCPA. We are assisting with updating privacy policies. As mentioned, we are not legal counsel in these circumstances, so we are requesting that dealers are seeking their legal representation to make sure the privacy policies are updated and that those policies cover not just the website but all services involved. You will be collecting data from multiple sources, and the privacy policies, even though they are on their website, do need to cover all of your sources of data. We are adding a do not sell banner or a do not sell notice that allows the consumer to find the privacy policy on the site, as well as the final point, finding the opt-out process, which may be a contact form or it may be a phone number or email address, which the consumer can use to contact the dealer directly to request either verification that data is on the system, what data that is, or deletion of that data.
Great. Thank you, Ed. Thank you, Alex. And thank you for listening. If you have any questions at all, please feel free to reach out to your performance manager or our support team at support@fcautomotive.com.